Good evening. This is Rahul Reddy. Every Tuesday, Reddy Neumann P.C. does bring in immigration updates, and we take live questions from 5 p.m. Central Time to 6 p.m. And today, along with me, is my business partner, Stephen Brown. And of course, we have a special guest, Joey from WR Immigration. I want to introduce about Joey, and he is, I would say, one of the culprit, I would say, is the person who is filling out the EB-5 so that it gets backlogged. That's the topic here, that EB-5, which Joey is specialized in, and then it's about to get backlogged for Indian nationals and Chinese national. And I would say that Joey is one of the reasons because he files so many EB-5 applications. Stephen, what good things or bad things you have about Joey?
Yeah, no, look, it's a good thing, right? We know that right now, after the RIA passed in 2022, the set aside EB-5 program has been the only program that's current for every nationality. I know we'll focus on Chinese and Indian nationals since they have the longest backlog in the EB-2, EB-3, and even the EB-1 categories, right, Rahul? And this has been a route that Joey's clients and our clients have looked into to get out of that backlog and look for a different route to a green card, especially, when we talk Indian nationals that have been here over a decade. We do anticipate there's going to be some sort of retrogression, whether that's on October 1st or later in the fiscal year next year. But there's still good things that can come on getting on board sooner rather than later with the EB-5 program, especially in the next couple of months.
And
Joey,
I would say,
can you tell me? Joey? Can you tell me that I know that EB-5 is current right now, and people can file the 485 application right now as of today. That's August 27th of 2024. Why are you anticipating that the priority date for the EB-5 is going to be backlogged for especially Indians and Chinese nationals soon, and that this is a window of opportunity where people have, if they want to get the interim benefits of getting the E8 in advance parole so that they are free, and they have to file the application right now? Why do you feel that it's imminent that the priority dates are going to be backlogged?
well, I wouldn't use the word imminent, but I do think at some point in 2025, we will see some final action dates for the reserve visa categories for China and India. And the reason why is simple demand and supply. We know that over 5,300 applications have already been filed. We don't know if they are in the rural category or the high unemployment category or their country of birth for the filer, but we know that there is a substantial amount of demand that is building up. And as USCIS processes and approves these cases and shows the demand to the Department of State, there's a limited supply of visa numbers that are available to meet that demand. So as the demand grows, but the supply actually starts going down, and it's going down because of the total annual allocation is going down from like the COVID years, which I'm sure you guys have spoken about before. As that goes down, there's going to be a point, in particular for those with the really with the per country caps, India and China, there's going to be some sort of final action date that is imposed. I was just talking with Charlie Oppenheim, who used to write the visa bulletin for the Department of State. He guesstimated that it will be open and remain current for EB-5 reserved through probably May of 2025. That's probably the worst case scenario. And so there is this unique opportunity right now to file your adjustment of status. And with that, you could potentially stop working for your non-immigrant visa employer as soon as you do that. Or it's a great backup plan in case there's layoffs and you aren't able to find a job within 60 days. You can remain here. Or your OPT is coming to an end at some point next summer. You can remain here if you file that adjustment of status beforehand. Now you can work once you get the EAD, you can travel once you get the advanced parole. And for those in the United States, that is a very unique benefit. For those outside of the United States, you have to wait for your I-526 to be approved in order to do consular processing. But because it's current, because of the concurrent filing addition to EB-5 that was put in the EB-5 Reform and Integrity Act, of 2022, there are some really unique opportunities that will not last long.
So Joey, I want to ask some questions, so basic questions though. I know that all of our audiences are very familiar with the I-140 and the priority date, which is backlog for EB-1, EB-2, and EB-3. They're pretty familiar that when you file the I-140, you cannot file the 485 unless the priority date is current. And at this point of time, as of today, the priority date is current and it's expected to be current for at least for some short period of time in the EB-5, according to your estimate. And that means that people can file I-526, which is very similar to the I-140, and file the I-485. And all of our audiences know that when we file the I-485, we can attach the EAD application and also advanced parole application along with the I-485. Now, what are the conditions for filing the I-526? How much investment is needed? What are the steps? Can you give us a timeline? Let's say I have the enough funds right now in my bank account and it comes from the legal source. What are the timelines that you are expecting to file the I-526 and I-485? And give the timeline aspects for my clients, please.
Sure. So let's just assume you've made a selection on the EB-5 project that you go with. Let's assume that you have already worked with an immigration attorney and gotten your source of funds ready to go. Yes, you have 800K in cash that you can invest, but you need to work with an immigration attorney to document how you earned that money and how that was lawfully obtained. This is something that can take 2 to 4 weeks, depending on how the source of funds, how motivated and organized the client is, if translations are needed. But assuming all of that is done, we file the I-526, the 485, the 765, and the 131 all together. The first thing that you will get are receipt notices. That's great. They don't really give you any sort of benefit. The first thing that's going to come in is going to be either the EAD card or a combo card, which is an EAD that says also serves as I-512 sort of advanced parole. There's no real rhyme or reason as to, for some they're giving combo cards, for some they're just doing EAD cards and then advanced parole a couple months later. I don't understand why there is differences there. It's differences for family members too. Like we have a wife that has the combo card, but the husband doesn't. It's sort of bizarre, but that's going to come, I would say, in 3 to 6 months after filing. Then your I-526 is the next thing that gets adjudicated. Your I-526 adjudication is based on a couple of things. One, has the project that you've invested in been approved? If it hasn't, they need to approve the project first, and then they can approve the I-526. But if it has been approved and the law that was written in 2022 is giving priority processing to rural applications. So if you're investing in a project that's in a rural location, they're trying to incentivize investments there, and that means priority processing. So if you're in a rural project with 956F approval, that's the project approval, you can get your I-526 approved in as quick as maybe 6 to 8 months. I've got an approval in 3 to 4 months. I think that was an aberration. But I would say the earliest these days that we're seeing is, as quick as 6 to 8 months. If it's a high unemployment, I am seeing it maybe anywhere from 12 to 16 months. And during this time, of course, you have your EAD and you have your advanced parole. Then once the I-526 is approved, then if a visa is available, they would have the ability to approve your adjustment of status application. And we're seeing that take maybe another 6 months or so after the I-526 has been approved while the visa bulletin shows it's current. I am on the AILA EB-5 committee, and we are desperately trying to get some sort of relationship with IPO and the California Service Center where they are adjudicating these adjustment of statuses so that it doesn't take that long. It shouldn't take that long for them to approve the adjustment after the I-526 is approved if a visa is available. You know, that's a 6-month delay as far as I'm concerned. And so we are trying to get them to speed that up and to work with USCIS to make it a little bit more efficient and streamlined for everybody.
So Joey, for
Yeah,
the for the for the I-526 to be approved, first the regional center application has to be approved. That's what you told. But what based on what you're telling is that even if the regional center has not been approved, when it's pending with the USCIS, that means when there is a regional center that goes to the USCIS and tells it to be classified as the place where we can invest the $800,000 and get the 526 approved, even while that is pending, you said that we can file the I-526. Only once the regional center has been approved, then the I-526 is going to be approved, though. That means that what happens, what are the probabilities of the regional center getting denied? And where can we find out these regional centers that have already been approved, where I can file the I-526, or that is about to be approved, or which the regional centers that are going to take a long time to get it approved? How do we come to know those things, though? Because my I-526 will depend on the regional center approvals, right? So first I need to know if it's already been approved, pending, or how far it is, what are the chances for it to be approved?
You need to speak with the regional center itself and see what they're selling. Or you can work with an immigration attorney who may know already, or you can work with like a EB-5 broker dealer sort of investment advisor who also will likely have that information. So there's a bunch of ways that you can find it out. I mean, there are good projects that don't have 956F approval because they were just filed, right? I mean, I wouldn't just go or just look at projects that only have 956F approval because you're going to be really limited. And a lot of those projects are probably already subscribed fully. And so there's no more spots for new investors to come into. The 956F approval is important for both eligibility and for timing. But if a project just filed a great project that complies and has great chance of repayment and a high return on investment, but the 956 F was just filed, that could also be a very, very good choice to go with if that's your EB-5 project. And I did realize that I forgot to answer one of your initial questions, Rahul, about how much money you have to invest at the time that you file the I-526. So the I-526, you have to show that you've made an investment of lawfully obtained capital. You can also show that you're actively in the process of investing lawfully obtained capital. I've had investors file their I-526, secure their priority date with as little as $200,000. And there are risks associated with this that we can talk about. And you obviously would need to agree with the regional center and the project about when the balance of the investment is going to get repaid or is going to get paid, excuse me. Generally, they're going to give you anywhere from 3 to 4 months or maybe 6 to 8 months, or I've seen it go as long as up to 12 months to make the full payment. So you can secure your priority date and then make the payment later. There are risks associated with that, though. For example, I had a client who did this. They put in 400,000. They filed. 956F was approved, and it was rural. And they got an RFE saying, "Hey, you only invested 400,000. Where's the rest of the money?" And so they had to, at that point, go transfer money from India to the United States. Thankfully, they had the ability to do that with a family member. And they had to show when responding to that RFE that, yeah, we've completed the full 800,000. So if you don't have the full money ready, then it may not be smart to go with that actively in the process of investing option. You really have, it's case by case basis. You have to discuss it with a qualified immigration attorney.
What about Joey? What about loans? I know that's a question you and I both got a lot. Is that post RIA we've changed up things, gifts,
What is
loans, all
RIA?
that.
What is RIA?
The
It's the
Reform and
EB-5.
Integrity Act.
Yeah, the EB-5 law that revamped everything in
Thank you.
2022.
Yeah, I just want to make it's
Yes,
clarified.
yeah, appreciate that. But loans and gifts, someone's like, "Hey, I got 600,000 ready to go, but I've got 200,000 in equity on my home. Can I do a HELOC?" Or, "Hey, mom's going to give me another 200K." How does that work? Kind of post 2022 for the loans and the gifts.
All right. So there are no restrictions on using funds that are borrowed or gifted to the principal investor for EB-5. You can use loans. Now, USCIS likes secured loans, but a court had said that you can use an unsecured loan, and that you can invest money that you've gotten and it's not secured by anything. So we've had cases approved where a friend is loaning money to the investor and it's not secured by anything. Now we have to document how the friend earned their money to show that that money was lawfully obtained. And we have a loan agreement between the friend and the investor, but that is absolutely an okay source to do. Or money is gifted from family members or friends, not a problem. We just need to document how they earned that money, that specific money. And that's where it kind of gets into the nitty gritty. It depends on the types of records that your friends and family keep. The other thing is with loans is, so you mentioned like the HELOC loan. So you bought a house for $500,000, you paid off the mortgage, now it's worth $1 million, and you have, you can take a home equity line of credit for a certain amount of value and use that towards EB-5. Absolutely, that works. They're going to want to know, how did you earn the money to purchase the home that you're now using as collateral to get the loan to make the EB-5 investment? But that works. Absolutely. So there are creative ways that you can take money out. I mean, you can get a loan on your 401k. You can take a margin loan on assets that you have in a brokerage account. That's also possible. The real key is, how did you earn the money to purchase that collateral? That's the real key on the loans.
Yeah, I use it as an extreme example, but it's kind of, and I've worked with attorneys on orphan adoption cases before, but similar to those cases where you want to go from the very beginning. It's when it comes to EB-5, that dollar leaves the Federal Reserve. How does it become part of your investment? They're gonna, and I think that's an extreme analogy, but how did you obtain it? If you're using a friend, how did they obtain it? Mom, how did she obtain it? Is this all lawful? Ways to do it. And I've seen cases, and I know you and I've talked about cases where, we had a company we formed and they had some issues as a company, and USCIS tries to attack the company having immigration issues in the past, that it's not a lawful source of funds. So I think, Joey, and you and I have talked about that. That's really one of the biggest roles of the immigration attorney in this, is that source of funds brief, right?
Absolutely. That's a key part, and it's a threshold issue. If you don't have the money, or you can't trace the money, or it wasn't taxed properly, it doesn't work for EB-5. Or if you transferred it out of India and you didn't abide by the rules of doing so, you probably don't want to use that for your EB-5 investment. They're going to be looking that you complied with local law as well as U.S. law. The cases I think that are the strongest is when you're using loans, it's a secured loan. That I think is the best way to do it. I don't really like going the unsecured loan route unless that's the only option. And with regards to source of funds, legal brief in general, a lot of my clients are doing that in parallel of looking for a project, because once you find the project that you want to go with, then you want to be able to invest right away, get your spot in the project, file your I-526, and get your priority date established. And you need your source of funds to be ready for that, because you need to file your source of fund documents with USCIS with that I-526. I would say it generally can take us 2 to 6 weeks to put together a source of funds report. I know everybody says, "Oh, this is simple," and it inevitably isn't. And it goes like Stephen said, it goes back further than you would think. And you got to work with a qualified immigration attorney on this. Working with a chartered accountant in India who doesn't know U.S. immigration law is a surefire way to get a denial. That's why Indian denials are higher than other countries. It's because I think it's because they're not willing to pay a qualified immigration attorney the money to do it. And they think they can just show, hey, I have this net worth. That's all it takes, and here's the bank statement showing the money leaving my account and going to the project. That isn't sufficient. And I guess the last thing I'll say on that is the legal standard is by the preponderance of the evidence, but what USCIS actually wants to see is clear and convincing evidence. I mean, it's and we can't fight them on that. That's a hard fight to do in court, but they really are, it's not more likely than not. It's clear and convincing.
We're talking a lot about priority dates and getting your priority date, and then also this possibility of retrogression. And obviously, our clients are familiar with that. We've seen it most recently, 2022, with the EB-1, 2, 3. But I want to make sure everybody is understanding of something. EB-5, unlike EB-1, 2, and 3, you can't port your EB-1, 2, or 3 priority date over to EB-5. So when you go to file the EB-5, you'll have a new EB-5 priority date. So, short term, depending on the amount of retrogression, it may not be too terrible, but you can't go ahead and port your 2013 EB-2 priority date over to EB-5. That's, statutory. It's not like we're not good lawyers and we can't do it. It's you cannot do it by law. So I just want to make sure everybody understands why we're talking about that importance of getting your priority date and locked in.
Yeah, that's a really good point. And there's nothing wrong or preventing somebody from being in multiple green card lines. You can have an EB-2 with an approved I-140 and you're waiting for it to become current. Same with EB-3. And now you're doing EB-5. You're just getting in a different line to get a green card. There's no restriction on the number of lines that you are in.
I mean, we've litigated with our mutual colleague Brad Manis. We've been litigating cases on that they were EB-2, they were current, they retrogressed, and they reached out to us and said, "Hey, I now got my 526 approved. Can you reach out to them about the 485 and doing the transfer of underlying basis on that?" And to your point, Joey, there's nothing wrong with even having a 485 based off of an EB-2. EB-3 and a 485 on an EB-5 and kind of see which kind of comes first. Now, look, I'm not going to sit there and say just go ahead and file 15 different 485s, but if you want to make that decision, there is nothing wrong with filing multiple, having multiple lines in the lake.
Yeah. And does the family members get to file the 485 along with the main applicant? Do they have to wait for the main applicant to get the green card?
No, they can file at the same time as the principal applicant.
Stephen, if somebody wants to contact you guys, we're going to provide a link at the bottom of this YouTube or the video, guys, so you can contact us. We'll give you information. You guys can contact us. We'll give a link about that. Is that right, Stephen?
Yeah, absolutely. So since we've did this starting in last February or earlier this year, we did a call with Joey, and I'll have an initial call, kind of see how everything looks, and if it looks like it's something, hey, you understand what you're getting yourself into. Joey's also willing to have that kind of final call, make sure everything sounds good. Again, Joey and I both feel adamantly we want you to feel comfortable with this process. Neither of us are here to sell used cars to anybody, right? We want to make sure, look, this is a legitimate immigration route, but it's also high stakes. And I understand that. And Joey understands that. We want to make sure you know the ins and outs, know what EB-5 is. And I think more importantly, what it isn't. I mean, I've seen plenty of people. Rahul always laughs. We went to a conference in 2018, Rahul, and all these high school kids were wearing shirts like, get your green card in 6 months, through investments. And they were going around marketing for this company. And I think it's important to know, I think there's a lot of misinformation on the EB-5 program. It's a great program. I think if it's something that works for you and your family, and we are at a unique time for it, but let's make sure it's going to work for what your immigration needs and wants are.
Joey,
Yeah,
as we
and I
move,
would say just 2 or 3 key points about doing EB-5 is, one, you got to get your source of funds in order. That's number one. Number two, you got to find a project that is going to meet your immigration and your investment goals. The project is the most important thing. The removal of conditions is based on the project and their ability to create jobs. Job creation is the key for EB-5. So that is critically important. And then number three, I would say, is you need an attorney who's going to be with you throughout the process, because it is not a short-term process. It's a long-term process. There's multiple steps involved. You're going to be dealing with USCIS for a minimum of 5 years, and you need someone who is going to be with you throughout the entire process until you have that permanent green card in hand for you and your family. And so that's what we like to do, and that's what we've been doing for many years. We have filed, over 5,000 of these EB-5 cases as a firm, and we would be happy to help anybody and talk to anybody who's interested. Yeah, absolutely.
Joey,
you said removal of the condition, Joey. So can you explain more about it? Like once I get the I-526, which is very similar to I-140, then I'm expected to get the I-485 approval, which unless, there's some criminal records, most probably that will be approved once the I-526 approved. Right. Isn't that the green card, or is it, did you said that it's only valid for 2 years and then you have to remove the conditions?
It's a conditional green card. So when your adjustment of status is approved, you're adjusting from your non-immigrant visa status to conditional green card, or from pending adjustment status to conditional green card. You get a card that says, your adjustment of status was approved on date X, and that's when your green card status began, and it's valid for the next 2 years. So you live, work, travel, hang out at the beach for that 2-year period. At the end of the 2-year period, you file to remove the conditions. There's a 90-day window that you're allowed to file this removal of conditions application. And the conditions are: 1, did the project create the jobs? And 2, did you sustain your money in the project for long enough? And if, again, those are both project-based questions. And if the answer to both of them are yes, then they will remove the conditions and give you the permanent green card. When you file the I-829, that petition to remove conditions, if you timely file it, USCIS issues a receipt notice. It's just a piece of paper that says, hey, your conditional green card status has been extended for 4 years. And so you would then use that piece of paper and your then expired conditional green card to travel in and out and to work and to show your lawful status in the United States.
You say that the jobs have to be created. So when we file the I-526, which is very similar to I-140, we file the 485. That's when not the jobs are created. By the time you get the permanent green card, that means when you go for the removal of the conditions, jobs have to be created. Is that right, Joey?
Yes, there should be jobs created by the time that you file the I-829. There actually is some leeway, and you have another year to show that the jobs can be created. But yes, you want the jobs created before your I-829. And these regional centers out there are actually structuring projects in a way where they're already starting to create jobs. And now they're using EB-5 to complete the construction project. And all of the jobs that were created by that project, whether through EB-5 capital or not, all of those jobs count. And so there are a lot of projects out there where you can get your spot in a project where the job creation requirement has already been met, and you can mitigate that immigration risk now.
Steven?
And I think what makes the regional center investment, I know that, just kind of to preface this for everybody, you can invest in a regional center or a new commercial enterprise, start your own business. Frankly, Joey's business partner, Bernie Woolsdorf, I think, said it best. You're going to invest a lot more than $800,000 to create those 10 jobs. What makes, I think, regional center investments interesting is you can count the indirect, right? Not just the direct investments like you have to for the new commercial enterprise.
Yeah, that's a huge and probably the biggest benefit for going through a regional center, is that you get to count the indirect job creation. When we think about jobs, we think about people on payroll, W-2s. But when you're going and counting these indirect jobs, you're really counting, well, how much is this money that is being spent in the economy, stimulating the economy and creating jobs for others? Or, you're doing, you're operating a hotel, and you're bringing in revenue. The job creation is based on the operational revenue, and they use these economic models to count these indirect jobs. And that is a huge benefit for EB-5 investors.
Based on Stephen and Joey, what you guys said is that there are two ways to file the I-526 application, based on your own business or based on the regional center. Regional center is most probably we are plugging in ourselves. It's not we are reinventing the wheel. It's just I'm plugging in along with 10 or 20 or 50 investors though. Now, Joey, can you explain more how this regional center works? How do they get the approval? What typically goes on there before I plug into that one? What goes on? What is a regional center?
Sure.
And how does it work?
A regional center is just an entity that's been designated by USCIS as a regional center, and their job is really to connect immigrant investors with U.S. companies and structure projects and sponsor projects and monitor and make sure that they are abiding by, U.S. laws, whether all sorts of U.S. laws, to support the immigrant investors application. That's their role. That you don't invest in a regional center, you invest in a project that is sponsored by a regional center. Some regional centers have their own projects. Some regional centers sponsor other people's projects. You have to kind of look into the details and the offering documents to kind of understand those relationships. But when a regional center files a project application, there's generally 4 or 5 main documents. First is the business plan of the project. Hey, is this reasonable? Is this actually going to create the jobs? And with that business plan, number 2 is the economic report. We're going to spend X number of dollars in this county doing this type of industry and why jobs are created because of it. The other parts that they're going to be including are the offering documents. So when you're looking at EB-5 projects, you're going to be getting a large document which discloses all of the risks. That is included with the I-956F filing, and as is the company's operating agreement or limited partnership agreement and the subscription agreement. All of that goes into the project application that USCIS reviews. Once they approve that 956F, then they should defer to that approval when they're looking at your I-526E, unless there's some sort of fraud or change of information or something like that would prevent deference. But that's generally the how they will defer to their prior adjudication on that 956F approval.
Stephen and Joey have a question for you. Why I should choose you guys? I will tell you what information I'm getting from outside and what information you provided right now. The information you provided doesn't look to be favorable to me. What I'm getting information outside looks to be very favorable to me. What I got information from outside is that I don't have to invest $800,000 at all. I only put $200,000. They are going to bring in some uncles, I don't know, uncle, whatever it is, not my uncle, somebody whom I don't even know. And they are going to bring the loan of that guy and they will invest in it. Oh, believe me, there are things that are telling. So I have to only invest 200,000. I don't have to invest $800,000. And they are telling that I get the green card. They never told me about conditional green card. This seems to be an invention of you, Joey, that conditional green card is. The other 10 people did not tell me anything about conditional green card. Now, why should I go with you guys? Why can't I just invest $200,000 and get the permanent green card instead of spending $800,000 plus the legal fees, and then I still get a conditional green card, and there's an additional legal fees for getting the conditional things removed?
Stephen, you want to start, or I can go? It's up to you.
Yeah, no, I mean, I'll start. I think, when we talk immigration, if it's too good to be true, it probably is, right? I mean, we see this a lot with EB-1, a lot of bad information out there and people thinking they can take shortcuts. Joey and the firm he's with has a lot of institutional knowledge. Joey mentioned he's on the committee, leading the committee for EB-5 for the immigration bar. That you don't get that by accident. You get that through years of experience. And I think one thing that also makes it a little bit unique is the way Joey and I met is because I was helping Joey with some litigation on some EB-5 stuff. Sometimes these things, you guys know, take a while. And when you can have the institutional knowledge on how to set up a successful EB-5, but also talk about the proper planning and expectations for an EB-5 and what that process is going to look like, I think that is where it becomes worth it to maybe not take a shortcut, not get a Walmart.
Yeah,
Oh,
and in
and
EB-5,
other
there's
thing before you comment, Joey. Oh, they are guaranteeing me 8 or 10% return on my $200,000, guaranteeing me, in which you are not. Go
right.
ahead,
Well,
Joey.
you can't have a guarantee because then it's not technically at risk, according to USCIS. Yeah, I mean, look, this is a lot of money, and I don't want to waste your time. I don't want to waste your money. The goal here is to get your family a green card, and then to get you your money back, and then if you can get return on the investment. That's the icing on the cake, right? But you want the green card and you want your $800,000 back. That's the key. Um, you want an attorney who's going to be with you throughout the process. I think that's key. You don't want to have to be switching attorneys in the middle of the process and get a new one all caught up. I think that is, I found that to be very challenging when I have taken on other investors' cases. You want someone who's going to be with you throughout. You want someone who's going to be on the cutting edge and know who and what they can do to get your case either sped up, like Stephen mentioned, or pushed forward, either at the USCIS level or at NVC. And like our firm has filed over 5,000 of these since the RIA was passed. I think there's been 5,300 EB-5 cases filed. We have filed, I believe, like just under 15% of those. So we are a top firm with EB-5. My managing partner, Bernie Wolfstorf, used to be the president of the immigration bar, the National Immigration Bar. So we have a lot of great relationships with attorneys all over the country. We get referrals all the time from attorneys because EB-5 is not a bread and butter for most immigration attorneys. H-1B, that's kind of bread and butter. EB-5 is specialized, and you need to know what issues to look out for. You need to know which source of funds is going to work and which isn't. And my job and Stephen's job and Rahul's job, we're not going to lie to you. We're going to tell you good news and bad news, and it's up to you to make the decision. The goal for us is to give you information so it's an informed decision. That's really what our role is here.
I have a question coming from Satyaraj from Facebook. He's saying, will the immigration attorney give guidance in selecting the immigration project?
That's an excellent question and one I get every day. There is some things that we can advise on and some things we cannot advise on. I am happy to advise on immigration risk, immigration compliance, regional center reputation. I am unable to advise because I'm not licensed to do this in the United States. I can't give investment advice. I can't give financial advice. I can't say this is a good project and you're going to get your money back, but I can evaluate a business plan for compliance. I can look at a PPM and say, well, this provision in here actually says that your money is going to be at risk for a little bit longer than this project over here. Those are the types of things that I can be looking at, but I can't really give financial advice. We're happy to connect you with people who are licensed to do that. That's no problem. And then you kind of have a team of advisors helping you make that decision.
The question that comes from Asim Javed, he's saying, what if the regional center business fails after a couple of years?
Another great question. So the EB-5 Reform and Integrity Act is very clear that if a regional center fails or is terminated, and there is a good faith investor who is suffering because of that, they can re-affiliate with another regional center and file an amendment and, like I said, retain your priority date and move forward with that new regional center investment. That's a new provision of the law that USCIS is actually interpreting quite nicely for pre-RIA investors as well. But for new investors, there is explicit language in the law that gives you protection against that type of possibility. There's an amendment part to it, but you still got to keep your priority date. And really, the project is going to be the same. You're just changing the sponsoring regional center, and that should move forward. I mean, there is a chance, though. Don't get me wrong. I mean, if you invest in a project that doesn't do well, or someone has never done it before, yeah, you could lose your money. I mean, I don't want to sugarcoat it here. People have lost their money with EB-5. They've lost their money, and they haven't gotten the green card.
That's where the problem. That's where the problem.
That's a huge problem. When you work with a good immigration attorney and you pick a good project that is going to be creating the jobs, already has done it, that's how you mitigate those risks. You want to make sure you get that green card. You want to make sure you get your money back. When people are saying, hey, we got 8, 9, 10% return on investment, I run away. I don't want that project. I don't want your return on investment. I want to be in the best position in the case something fails. How do I make sure that I'm getting my money back? There's risk and reward involved here. I'm more of a low risk, low return type of guy. I think that's the right way to do EB-5. Not everybody agrees with me. There are attorneys out there that are bolder than our firm. We are very conservative and cautious. We don't like getting denials, and we don't get denials because we don't file those cases. That's why we kind of have to do our own due diligence on the source of funds and everything else before we actually file it.
Yeah, I think that's something that stuck with me, Joey, when I first started talking to you and Bernie on this, is that there's really 3 goals with an EB-5 filing, right? And in order, priority here that we're going to focus on is, number 1, priority 1 is going to be get your green card. That's the reason we're doing this, right? Is get you your green card, get you and your family off of a non-immigrant visa, stop aging out, your kid. That's number 1. Number 2, get your $800,000 back, right? If we can get you your money back, that's great. But first priority is the green card. And then number 3 is, can we make a little bit of a return on investment? But again, that's the kind of order of what we're looking at in terms of priority, is get the green card, get your money back. And then if we can get those and we can make, and you can make money on it, great. But we want to make sure 1 and 2 are satisfied before we get to 3.
Right. Absolutely. Yeah. You're not going to get rich doing EB-5. You're going to get the green card. Then you can take that money that you have, done EB-5 securely with and go get rich afterwards.
And I think that leads to a question I think you and I both see a lot. How long is my investment? It's got to be at risk. How long is my $800,000? That's all. That's my life savings. I've liquidated my Robinhood account, my brokerage account, and all that. When can I get my money back, Joey?
So there's the legal requirement, and then there's the actual business deal. The legal requirement is that your money must be at risk, sustained for 2 years after it has been spent. That's the new guidance that they have. So for 2 years, the money gets sent to the project, they spend the money. That is when the 2-year period starts. Now, when you actually can get the money back depends on the project. If there's a loan agreement and the loan agreement is for 5 years and the borrower doesn't have the obligation to repay the money for 5 years, then you wouldn't have an expectation to get your money back before that 2-year period. So it depends on the project, but you can get your money back after 2 years of it being used by the job creating entity without it impacting your immigration case. And on their website, they are very clear in their Q&A that you can actually get your money back even before your I-526 is approved. They say that on their website because this new sustainment requirement.
Anything else, Stephen, this topic?
Yeah, so I think one of the other questions we get a lot, and I think one of the reasons I feel most people are motivated by EB-5 is the Child Status Protection Act, CISPA. I came over 2012. My child was a few years old. I figured, okay, the U.S. immigration system certainly isn't as broken as it is in 2024. I'll get my green card before my child turns 21. And unfortunately, we know that that's not always the case. And there are people who are the children are aging out. Does CISPA still apply to EB-5, Joey?
CISPA absolutely applies to EB-5, and it's a real big reason why a lot of people, for the reasons you just mentioned, are going here. It's for their kids. They don't want their kids to have to get on an F1 and have to deal with H-1B themselves. They want that freedom for their children, and it's absolutely, the way that I'm looking at it is when you file that adjustment of status, because it is current right now, you are locking in their age. And that is a huge benefit and a huge headache and burden off a parent's head.
Yeah, I think the CISPA protection. I mean, I think probably 80% of the calls that I take on EB-5 is that's the motivator, right? Is the child, and the age out kid's a terrible system that we've created, but props to parents for thinking about alternative routes other than just waiting and going through the traditional F1, H1, and have their kid go through this process. So EB-5 is certainly an option. And again, I want to make it clear, I've talked to people who say, "Oh, I can't do it," and it certainly isn't for everybody. And I understand that, but it is an option, and I think there's a lot of ways to find benefit in the program.
Yeah, I totally agree. It's sort of like one of the only options for Indian nationals right now who are stuck in the backlog, and that's why. I mean, I was talking to some. I think I'm working on like 18 cases right now, and 17 of them are Indian nationals on H-1B. I mean, it's just that's the demand that is coming up right now. It's just on how the circumstances have played out, and seeing this green card line go faster than EB-2 or EB-3.
And Cash brings up a good question on YouTube. Biggest blocker for him is where to get a safe project. Do you provide guidance on that? And so we talked about that a little bit ago. Joey and I are not investment, or financial analysts or have the right SEC licenses to even give that kind of financial guidance. But there are people out there that are certified and are licensed to do that. I know Joey, I know y'all's firm works with some very closely that have the ability to look at both, understand the immigration side as well as be able to look at the financial side and give you some of your options, talk you through that, but also, know what they're looking at and have built some of those relationships.
Yeah, I mean, EB-5 offering, if you were to give it to just a standard financial advisor, they would have no idea what to do with it. So you got to work with someone who's reviewed many of these, and we're happy to put you in touch with folks who can help on that side. But yeah, you don't want to take financial advice from an immigration attorney. That was a line that Emily said in February, and I've been using it since then.
I think I went to a conference and probably 150 lawyers in there, and one has gone through the SEC process to get licensed as a licensed registered dealer broker, and that 150 attorneys in that room or more, and one went through that channel.
Yeah, it's a different, a totally different discipline. Absolutely, different knowledge. So,
anything else, Stephen? Before we go to some questions.
No, go ahead, Rahul.
I see some questions that is coming out. V2 from YouTube has this question. He's an H-1B. He's married to a U.S. citizen. What do you advise to file I-130, I-485, EAD, and AP to file together or to file it separately? Absolutely, file it together. File I-130, I-485, and EAD and AP together. That's what I strictly advise. HF has this question. He just came to United States on advance parole. On the same day that he came into United States, his green card got approved. Is that going to create a problem because he came on advance parole? Is his green card is going to validity will have an issue? Absolutely will not have any problem. None whatsoever at all. You'll be fine. Your green card is still valid. I've had some situations where people's green card got approved. I had them travel on advance parole. At the port of entry, they let them travel, did not have any problem, and still no problem for the green card. There's no problem for you at all. You are a green card holder. Congrats. Enjoy your time.
Yeah, we've seen some people get approved on their green card on they traveled on advanced parole and they've got approved on the flight, and trying to figure out how that works.
Jay has this question. His I-130 for his parents have been approved. How long it will take for the NVC and the whole process to get the green card? Typically, once the I-130 has been approved, it's taking anywhere between 9 months to about years time by the time people get the green card, especially in the consulates in India, though. PS asked this question. The company's I-140 has been approved. Now the company has been acquired. Does it require that the new company needs to file an permanent I-140 or just need to file an amendment? It depends on the acquisition. If the new company is a successor of interest, it's a little bit technical definition, but if it's a successor of interest, which most of the acquisitions, I would say about 90% of them will fall into that category, the new company does not need to file a POM, but they need to file an amended I-140 approval. But for me to tell it very clearly, I have to speak with the HR to figure it out if it is a successor of interest or not. AK has this question from YouTube. His son's first name, there has been a letter cut out, and his son's first name has 18 characters, and one of the letter is cut off. Is that normal? Is that going to create any problem? Absolutely not a problem. This is not going to be any problem for your son to get into the country, outside the country at the time when he gets a citizenship. It will not be a problem. They already did the biometrics, so it'll be fine. He should not have any problem.
Well, if I can interrupt, I saw a couple questions come in on secure loans versus unsecure. Joe, I don't know, did you have to take secured transactions in law school? That was always...
I didn't take that one, but I did for my bar prep. Oh, yeah, absolutely.
Yeah, the professor I had helped write the UCC comments, so it was very dry. That's going to be a thing with your bank, right? So if I go down to the bank here or a loan provider, however that works, and I say, hey, I want a loan for X amount, you have what are called secure loans and unsecure loans. So unsecured loans are typically considered your credit card, right? That is not secured by collateral. You owe that money, but there's no lien on anything. Secured loans consider like your house, your mortgage is a secure loan. So the bank, however they go about their loan servicing, is going to offer secured or an unsecured loan, and how that works in banking and UCC and all that is well beyond me. I remember having to learn how to perfect it and all that years ago. But a secure loan is going to be backed by collateral. So that way, if you don't make payments on the loan, there's something for the bank to repossess and sell to make their money back.
Yeah, and generally, I said this earlier, but there's a lot of different ways. There's no restrictions on what collateral you use to get the loan. It's about documenting how you earn the money to get the collateral in the first place. And so, it could be a house, it could be a car, it could be, I don't know, a piece of art. I mean, it could, you have to show the fair market value of the asset, but anything can be used. And I think that's right. You kind of have to work your banking relationships. If you have a home and you have some additional equity in it, you can do a HELOC and get a loan based on that. The amount will obviously depend on how much equity you have and the risk that you will be able to or won't be able to repay it. So that is very personal circumstance based.
Question from YouTube. His name is for YouTube. He wants to move to H4 and EAD. His spouse's H1B is about to renewed. Do you recommend filing the H1B, H4, and EAD together? Absolutely yes. If you file it together, you are going to get the approval together. If you don't file it together, you may not get the approval together. So I strongly recommend H1B and H4 and EAD to be filed together. And if your spouse files the H1B in premium processing, all three, H1, H4, and EAD, all three will get approved at the same time. That means, and you don't have to pay extra premium processing for H4 or EAD. It's only you pay one premium processing for H1B, you get the H4 and EAD together. Thanks to Stephen Brown, our business partner. He was one of the litigator in the class action suit, which even though you contacted Stephen Brown, he represented everybody in that particular class action, and you are covered by it, that if the H1 and H4 and EAD has been filed together, you should get the approval, and thanks to Stephen Brown for that. Okay. Questions, how long can I work outside the country on H1B? First of all, when you are outside United States, you're not an H1B. So let's say, for example, you are in India, you are an Indian citizen. The question is that can an Indian citizen work in India? Absolutely they can. They don't need to have a H1B. Look at all the people in Infosys, Wipro, Deloitte. You go to Pune, Hinjwade, you go to Gachibowli area and Hyderabad, thousands and thousands of people are working. They don't have even any work permit. They're remotely logging into USA and working. So people who want to remotely log in and work from India, they don't need to have any work permit. So they can work however long they want to. No immigration rules are applicable to them. USA and India does not recognize remote working as working. Where your butt is sitting, you must be allowed to work. So if your butt is sitting in India, you must have a work permit in India, or you must, since you're a US citizen, since you're an Indian citizen, since your butt is sitting in India, it doesn't matter whether you log into Mars, Moon, or to USA. You are allowed to work because you are an Indian citizen, your butt is sitting in India.
Hopefully you're not stuck on an International Space Station for an extra 6-7 months trying to work.
I really don't know the answer though. If somebody is there in the space station, whether they can work or what jurisdiction they come in. Most probably it will be the space station, which country it belongs to. They must have a work permit for that, I guess.
Yeah, I don't think U.S. immigration law would apply there.
Well, that's, if they ask a question though, I'll give a free advice to them. I had H1B used of 5 years and 9 months. If I get an I-140 approval, can I get an H1B right now? Can I get the H1B again? So this question is coming from Jahangir Khan. He's been out of USA for 5 years, but he has used up 5 years and 9 months of H1B previously. And if he gets an I-140 approval now, after 5 years he spends outside the country, can he get the H1B because he has been counted toward the H1B before? The answer is yes, yes, and yes. If you get an I-140 approval, you don't have to go to the lottery since you have 3 months left in the H1B, and based on the I-140 approval, you don't come under the 6 years limit. You can still get the H1B approval. Not a problem at all. Last question for you, I guess. So loan against property, does it count as a lawful front for applying EB-5? This question is coming from Nash Red.
Yes.
Josh?
Yes.
Okay.
Yes, it can count. Just show me how you earn the money to purchase the property. And if you have a mortgage, show me the mortgage. Show me the closing statement. Show me the bank statement of your earnest money deposit. I mean, there's things that we will need, but yes,
how about the income
it's
tax?
A very common way.
How about the income tax returns
for the year that they purchased? Yeah, well, the law now says you're supposed to do it for 7 years. You're supposed to provide your last 7 years of tax returns, and that technically also is a requirement for anybody who's gifting or loaning money to you, unless the entity loaning to you is a bank.
No, nowadays we can just go to irs.gov and pull that information out more easily than before.
Yep.
Real quick plugs here for information. Always welcome to reach out, info@rnlawgroup.com. We also have a WhatsApp group. I don't think we have the link right now, but if you email us, at info@rnlawgroup.com. Joey, myself, Rahul, Emily, Bernie is in there. Bernie Woolsdorf is in there as well. Look, we know there's a lot of questions about this. We know there's a lot of this is a big investment, so you have a lot of questions. And again, like I said earlier, we want you to feel comfortable about this. So we're happy to kind of address some questions. Some of them may require more one-on-one, but there are, I think, a lot of questions that are generally applicable as well.
Thank you guys for tuning in. But you can also consult Stephen or me or anybody in our team at any point of time. The link is provided at the bottom. Thank you, Joey, for coming and answering all the questions. Thank you for the
great job.
Of course,
thank you for inviting me. Appreciate it.